Some gun rights advocates are calling this a bombshell decision that could change the game when it comes to self-defense encounters.
They're talking about a ruling by the state Supreme Court that sets a new precedent in Minnesota's duty to retreat laws.
So for a long time on this channel, we have talked about different various self-defense laws in this nation. But right now, today, as you heard in that local news segment, we actually got a ruling from the Minnesota Supreme Court that is absolutely insane and essentially completely neutralizes self-defense in that state in a great number of circumstances. And this, of course, is their great expansion of the duty to retreat of the victim of criminality in that particular state. Now, this was a 4-2 ruling. It's asinine in every possible way. I'm going to talk to you about the case that ultimately ended up leading to this ruling and how far beyond even crazy states with duty to retreat like New York State, this has actually pushed the duty to retreat. Now, we're going to get into this, but before we do, especially right now, as I am completely unmonetized due to YouTube screwing me over, thank you to everybody who supports this channel via actualjusticewarrior.com/join.
Give me the money. Give me the money, okay?
Well, in Minnesota, there's a duty to retreat when reasonably possible before using a deadly weapon. But the new ruling says there's a duty to retreat before even showing a weapon.
So on its surface, I can understand why somebody would say a duty to retreat is actually reasonable. The whole point of self-defense, the whole point of these kind of laws is because you're trying to reduce significant harm to individuals in these particular instances. So if you don't have to actually engage in a fight, you don't have to actually engage in an encounter, then it makes sense for you to actually avoid said fight or said encounter. But the problem is that when you have the law tilted this way, and that's on the books, you end up in a situation where prosecutors can Monday morning quarterback each and every potential self-defense situation, and rather than the presumption of innocence being on the person who was being victimized by criminals and needed to defend themselves or ended up defending themselves, the presumption is that that person is the criminal and they're at fault for those actions. And that's exactly what happened right here. In fact, in the Supreme Court ruling from the Minnesota Supreme Court, you could actually see them Monday morning quarterbacking what this person should have done, and it actually is insanely absurd when you think about it.
Some gun rights advocates are calling this a bombshell decision that could change the game when it comes to self-defense encounters.
Now, look, gun advocacy organizations obviously have specific agendas that they're trying to go for, just like everyone, so they can assert that and the local news can repeat that, but what we actually need to look at is the case at hand. We actually need to look at the ruling to see if that is actually a legitimate interpretation of this Minnesota Supreme Court case. And the fact of the matter is, when you read it, you find out it is a legitimate interpretation. Let me go to the documents themselves so you can see it. By the way, they will also be linked in full in the description so you can read this decision for yourself. Right under where it says syllabus, it says the duty to retreat when reasonably possible, a judicially created element of self-defense, applies to persons who claim they were acting in self-defense when they committed the felony offense of second-degree assault fear with a device designed as a weapon and capable of producing death or great bodily harm. Now, right off the top, this is incredibly crucial because what we're actually talking about here in terms of the assault is the instilling of fear in somebody, because a lot of people don't realize that in most jurisdictions in this country, the actual physical harm that people associate with assault is battery, but the threat or the intimidation or putting somebody in reasonable fear that they will be battered is considered assault. So right here from the top of the ruling, they're not talking about actually using a deadly weapon in order to fight off an attacker. They're talking about presenting a deadly weapon in order to scare off an attacker so that they would feel like they're in serious bodily harm if they continued attacking the victim. So as far as what the Gun Owners Association has said, what they have put forward, this is in fact the case. The duty to retreat in terms of the state of Minnesota now expands not only beyond the action of actually fighting off an attacker, but it in fact expands to the point where you would even present a weapon in order to scare off an attacker in order to prevent anybody from getting hurt. And again, when you get to the opinion, it is clear. The case presents a narrow issue of first impression. Whether the duty to retreat when reasonably possible, a judicial created element of self-defense long established by our court applies to a person who claims they were acting in self-defense when they committed the felony of second-degree assault fear with a dangerous weapon. For this decision, a dangerous weapon is limited to a device designed as a weapon capable of producing death or great bodily harm, according to this Minnesota statute. Appellate Early Romero Blevins pulled out a machete on a light rail platform in downtown Minneapolis and brandished it at a woman and two men for nearly 1 minute with the specific intent to cause them fear of immediate bodily harm. Based on the conduct, the state charged Blevins with 2 counts of second-degree assault fear with a dangerous weapon, a felony-level offense. The legislature deemed the act of committing assault with fear with a dangerous weapon to be harmful, with a maximum sentence of 7 years in prison. So even though gun owner organizations are the ones that are pushing back on this particular ruling, it is important to understand that this does not involve a firearm. What we have is a man called Blevins who was arrested for brandishing a machete at 3 individuals that he believed were threatening him, threatening to victimize him, and what we're ending up in an argument about on this light rail station is whether or not he had a reasonable ability to retreat, or if it was such a bad crime for him to brandish a weapon for 1 minute that he should be charged and sentenced up to 7 years, because that's not covered under self-defense.
When the Minnesota Supreme Court upheld 2 second-degree assault with a deadly weapon convictions against a man with a machete who was threatened by a man with a knife at a Minneapolis light rail station, the state's highest court also set a new precedent involving Minnesota's self-defense laws.
Now, the facts of the case are as follows. On June the 2nd, 2021, Blevins was on a light rail platform at US Bank Stadium Plaza station in downtown Minneapolis. A woman with a teal shirt, a man wearing a sweatshirt, and a man wearing a tank top were also on the light rail platform. The woman and the 2 men knew each other, and they were loitering on different parts of this platform. When Blevins walked past the woman, she said something to him, and Blevins responded angrily. While Blevins and the woman continued to argue, a train arrived, people stepped off the train, and as the train sat in the station, the man in the sweatshirt, who was armed with a knife, absolutely crucial, walked toward Blevins and the woman. According to Blevins, the man in the sweatshirt told him to come into the platform shelter outside of the view of the surveillance camera so that he could slice Blevins' throat. In response to the threat, Blevins pulled out a machete from his waistband. Blevins then moved toward the woman and the man with the sweatshirt, yelling, holding the machete. The woman and the man began backing away from Blevins as the man in the sweatshirt put his knife away. The man in the tank top aggressively walked up to Blevins. Although Blevins feared for his safety, he did not try to walk away. Instead, Blevins moved forward towards the woman, pointing the machete at her as he yelled. Blevins also lunged at the man in the tank top while holding the machete in his hand in an aggressive manner. According to Blevins, he was trying to get the woman and the 2 men to back off. Blevins yelled and swung the machete at them for approximately 1 minute, causing them to retreat. As they retreated, Blevins took a less aggressive posture, although he continued to yell. So it's important you understand the facts as they are being considered by the court, because this is, of course, what they're ruling on. Essentially, what happens is that an altercation ends up happening between Blevins and 3 individuals, 1 woman and 2 men. During the course of that altercation, which was initiated by the woman, one of the men pulls out a knife and threatens to slice his throat. In response, he draws his own deadly weapon and he begins to try to scare them off. After that happens and these 2 end up moving away, the 3rd individual, the one in the tank top, ends up approaching him aggressively, so he responds with aggression, again, in order to deter them from attacking him. Nobody was stabbed in this instance, nobody was cut or anything like that, and ultimately his strategy of pulling out the machete and waving it around ultimately ended up leading to, again, them retreating and thus the incident being over. So right now, we have a situation where, according to the court, Blevins was threatened by multiple attackers with his life being taken. A weapon was presented, and in response to that, he drew his deadly weapon to meet the threat, and yet he is still guilty of second-degree assault for putting them in fear that they would be injured based on the fact that they were threatening his life. Again, you can see how absurd this is. But let's talk about the Monday morning quarterbacking, because that is also in this 4-2 judicial opinions.
In a split decision, the court wrote that long-standing Minnesota law says that a person needs to retreat when reasonably possible, even when facing bodily harm. And that security video contradicted the man with the machete's claim that it was not reasonably possible for him to do so.
Now, Blevins actually opted for some reason for a trial by judge instead of a trial by jury, and during the course of that trial, he was ultimately convicted, and he had a presumptive 39-month sentence, which is a little more than half that you would get for the crime of second-degree assault by fear, which is what he was convicted of. But what he argued then and on appeal is that he used reasonable force against another while resisting or aiding another to resist an offense against the person. So because he was threatened with deadly force, he believed that the fact that he engaged in not deadly force, but the threat of deadly force in response, that was reasonable in that particular case. But what the court ended up saying was that his duty to retreat was not met, and his argument that he couldn't do it in the face of these three attackers was not reasonable because of this insane Monday morning quarterbacking situation that these judges decided to hoist upon this poor guy. Again, this is from the ruling. Addressing the sufficiency of evidence under the standard applicable to direct evidence here, the surveillance videos clearly show that Blevins had room behind him to retreat and could have walked at an angle, keeping an eye on the woman and the two men while he retreated. Moreover, at various points, the woman and the two men turned their backs to Blevins while he's brandishing the machete, giving Blevins an opportunity to retreat from them. Thus, when viewed in the light of the most favorable verdict, the evidence presented at trial disproves beyond a reasonable doubt Blevins' claim that it was not possible for him to retreat. So let's get an idea of what this particular ruling actually said. According to them, because the surveillance video shows that there is room behind him at certain moments of time that theoretically he could have ran at, again, at an angle, according to the court ruling, therefore he did not meet the basic threshold of the duty to retreat. But the thing is, any self-defense expert will tell you that when you have multiple potential attackers, by the way, one of them clearly and unambiguously had a deadly weapon, that is not in dispute, brandished said deadly weapon first, it is not a great idea to run from said attackers. What he was making the argument for, Blevins, is that he needed to basically go crazy, he needed to whip out the machete and start swinging it around in order to deter the fight, in order to deter them from attacking him, because he wanted to put them in fear in order to defend himself. And he did not use deadly force, just the threat of deadly force, in response to the threat of deadly force, again, coming from multiple attackers. I happen to believe that this ruling is absolutely insane. Even in states where you have a duty to retreat, this is not a typical response, although this is always the potential that you have in a self-defense situation when your state laws do not protect the defender and instead protect the criminal.
But according to Rob Dorr, the vice president of the Minnesota Gun Owners Caucus, the ruling means anyone who uses a deadly weapon in self-defense must look for a reasonable way to retreat before even showing a weapon.
Now, when I say Monday morning quarterbacking, I 100% mean that. And I really want you to think about how this case unfolded and how it's actually reasonable to think that this case could have had additional layers to it if you just pay attention to the facts as they were presented. So we have an initial argument between the man and the woman. It is initiated by the woman, and then another man in a sweatshirt comes at him with a knife. So already we have an argument that was a single one-on-one argument with a man and a woman that escalated when a third-party additional attacker ends up entering the situation. Then he pulls out the machete. The machete, obviously, he's waving it around for a minute, and during the course of time where he's waving around the machete, an additional attacker ends up showing up, and this is the third person that he engaged with. Now, the court is saying that because there were certain points where briefly they were not looking at him, where they were backing away, and because he could have retreated at an angle on this light rail station platform, that he should have went for the run. He should have just tried to get out of there. But in this particular situation, in that particular moment, you've already got into a situation where one attacker has turned into two attackers, who has turned into three attackers. So is it insane to think that maybe if you were to back away from this situation, you might back into a fourth attacker? I don't think that is insane at all. I think it is very logical that he did not retreat in this particular situation. And again, I'm not in favor of people carrying around machetes and waving around like crazy idiots, but the fact of the matter is, in this situation, running into a potential fourth attacker while you're retreating is not an ideal outcome. It's not what self-defense laws should require of victims of crimes in this particular instance or in any instance, but this is what the court is ruling. What they're saying is, well, in hindsight, according to the surveillance surveillance video, looking at this from miles away 3 years later, we have decided that there was no potential additional danger to this individual, even though, again, in this particular situation, we've already seen escalations, additional people pop in. They have decided, well, it was reasonable for us to determine for you in that moment that you should have assessed everything, known all the possible angles, kept your eyes on the attackers, and backed away and hoped that there wasn't a fourth person involved.
Minnesota is one of the states that in the minority that does have a duty to retreat. But now with this decision, we are literally the only state in the country that requires you to retreat before you even present a force option.
In a dissenting opinion, one of the justices wrote, not only is the court's decision unprecedented in the United States, it also flies in the face of human nature. A view Dorr agrees with, saying in the moment, most people don't have time to look for a way to retreat before grabbing or at least showing their weapon to defend themselves.
This is why this is such a bad ruling, but more importantly, more fundamentally, this is why a duty to retreat, especially one that is this unreasonable, is so crazy to have in your law, because in this particular situation, the person who is unambiguously being victimized, being threatened with murder, is going to be sentenced to 39 months in prison, no mitigating circumstances, as if he was the one who initiated the assault. And to make matters worse, because there were 3 attackers and because he responded to 3 attackers, he is actually considered worse than the person who pulled out the knife in this particular situation, because he ended up threatening 3 people, even though, again, he had 3 attackers. So yeah, this is an absolutely horrible ruling. These judges should be embarrassed. But are we surprised that Minneapolis in 2021, post George Floyd, post the Black Lives Matter riots, post not prosecuting anyone for anything, decided that a self-defender is the one that they want to go after so hard? And are we surprised that the Minnesota Supreme Court ended up affirming this and instituting a ridiculous standard that, again, is far beyond what we would expect even in crazy duty to retreat states like the state of New York? But you know what? Those are just my thoughts. I want to know what you guys think down in the comments below. As usual, if you like this video, then you should show me by leaving a like, subscribe for more content, follow me on the social media, support me via the support links in the description of this video. This has been me talking about Minnesota getting rid of self-defense. Till next time.